Hello, Mr. Perez. I'm doing okay. How are you doing? All right, what is the update on the mental health evaluation?
Judge, may I comment on that?
Yes.
I just reached out to Lori because I had done the application online for the assistance from the MAC and they didn't respond. So I finally spoke with Lori, maybe a few days ago. And I filed a motion for the mental evaluation and they're gonna get back with me on that. I'm not sure how long that process will take. But he's
Right,
gonna-
Norma, can you call the magistrate's court, ask them if they received the evaluation? Because the court has already signed it.
But we had kind of discussed that strategy going forward either way, Judge. I just filed a motion to be absolutely certain that's done.
Okay,
I apologize for not being here on Monday.
no problem.
No one's answering.
All right, set this for January.
Next January 12th.
All right, they should have information on your competency evaluation at that time. Thank you. Do you have any questions about anything? All right, thank you.
Thank you, Judge.
You're welcome. All right, State Engaged, Gara, have you had a chance to review the defense's request for bond? Are y'all ready to proceed? All right, court is calling 2025 CR 008. I'm sorry, 2025 CR 006868, 2025 CR 006869, 2025 CR 006870. State versus Gage Gara. Could I have parties announce?
Trey Maurer for Mr. Guetta.
And are you Mr. Gara?
Yes, ma'am.
All right, defense is requesting a bond be set in each of these cause numbers. Does he not currently have a bond counsel?
Your Honor, his bond, he's currently remanded without bond. I believe through my conversation with Lauren that we have came to an agreement to reinstate the current bonds.
Well, I see here that he was remanded without bond based upon a violation report. Does anybody know what the violation
Your
report
Honor,
is concerning?
I believe it was that he FTA'd on a misdemeanor out of County Court 9. And then I believe that, and then you issued a judge's warrant based on that FTA, I believe is the timeline of events.
All right, could I have a copy of the violation report, please, if anyone has it? Counsel, if you would give us a moment while I pull that up.
Okay.
Because I want to make sure the ruling I make is an appropriate one. Just
Okay.
give us a moment.
Yes, would you like my client to sit down?
Yes, and let me give that to you.
Thank you.
I need the order that I ruled upon. Ah,
That what you're looking for?
yes, thank you. All right, I'm sorry about that, Mr. Gara. I know he has crutches. If he wants to remain there, he can remain there. All right, we're back on the record. So, State, in regards to this case, you're asking that the previous bonds be the same amount be reinstated?
Yes, Judge, on the phone, I would ask, or this week, defense counsel and I agreed on releasing a $12,000 bonds because the actually from and that one was already dealt with.
Okay. And how was it resolved?
That one's still showing pending as well as these felonies, and it looks like it is, the misdemeanor is next set on 12/4 for the agreement, so I can just send it over after.
And Your Honor, I'm not sure what's going on with the misdemeanor. The attorney record he had on these felonies is also the attorney record on the misdemeanor. That attorney withdrew on all felonies. I'm not sure if he intended to withdraw on the misdemeanor as well, but he still shows the attorney record on that case.
And I'm assuming he's on ignition interlock?
Your Honor, again, I'm not the attorney of record on that case, but I can pull it up and see right now.
Okay.
I don't see the ignition interlock ordered on this case, Your Honor. Not that I can see.
All right. In each cause number, the court is going to set the bonds at $12,000. The court is going to order outpatient treatment, waive the fees.
This is a textbook example of multi-tiered court orders. Bones aren't just about money. They come with strings, outpatient treatment, substance abuse programs, ignition interlock. Basically, the court is building a compliance roadmap. Show up, follow conditions, and you avoid incarceration. For viewers, this is why bail isn't just a fee. It's a mechanism to manage risk while giving someone a chance to stay out of jail.
And that's outpatient treatment for substance abuse. And there will be ignition interlock on all accessible vehicles. All right, and let me see what date we're gonna come back
I
on.
have a 12-4 date, Your Honor, as a final discovery in here.
All right, well, we'll keep it at 12/4.
Thank you, Judge.
All right, is there anything else?
Your Honor, just for clarification, did the court reinstate the existing bond or did they just reset it at the 12,000?
I'm resetting at $12,000. If you call the bondsman and the bondsman wishes the bond to reinstate it, then the court will order it as a reinstatement.
Okay,
All right, is there anything else?
nothing from defense, Judge.
All right, and counsel, if you have that information for the bondsman later today, just let the clerks know.
I know the bondsman was also his attorney, so I do not anticipate
Ah.
them wanting to go back on.
All right, thank you.
Thank you, Judge. You're excused. Or I have
Yeah.
another one, but I need to speak with.
All right, thank you. All right, Audrey Bash. All right,
On
Uh,
this case, we're still waiting for a PSI interview to occur. In the meantime, Ms. Bash has taken additional classes, and this gives her additional time to take a few more classes, and she's currently enrolled. There's a verification letter that she's doing more substance abuse classes.
all right.
And we-
So on this case, does anybody want to see if the court can get an expedited PSI?
That would be great, Judge.
All right, so just give me a moment and I'm going to see if I can get this. It would have to be at the beginning of December.
That would hopefully mean that they're back here before Christmas.
Yes.
That's the goal.
All right, so let me make a phone call and then we'll see if we can get that done.
Yes, Judge. You want Ms. Bash to have a seat?
Yes. After December 4th.
Yes, Judge.
All right, what date?
Yes.
Is December 12th okay? All right, Ms. Bash, we'll have you back on December 12th. All right, I'm sorry that there was a communication mix-up, but we'll have it done by then. All right, thank you. December 12th. Are y'all ready on Deleon? All right, Mr. Deleon, if you'll come down. All right, does anybody have a copy of the motion to revoke?
I do, Judge, but it's full of notes.
Okay, let me see. I can pull it up in the email. Ms. Abrams sent it. It's just, sometimes it's easier seeing the paper.
I wouldn't want to expose this court to the prejudicial notes that I have here.
Oh, let's not do that. And Mr. Deleon, I'll be reviewing the motion to revoke, not to decide whether or not things are true, but just to make a decision on if I were to grant your motion for a bond, that the conditions I set are appropriate. Okay. All right, while they're printing it out, the court is calling 2024 CR 3774 State versus Luis Deleon. Could I have parties announced for the record for the state? Defense? For the defense?
Patrick Ballantyne for Mr. Deleon.
And are you Mr. Deleon?
Yes, ma'am.
State, any objections to the defense appearing by Zoom?
Judge.
And Mr. Deleon, do you have any objection to your counsel appearing by Zoom?
No, ma'am.
All right, you are here. Oh, thank you.
Well,
You're here requesting that a bond be set. Is that correct, defense?
That is correct, Your Honor.
All right, and it's the court's understanding that you all have reached an agreement?
We
As to
have.
a judge, but perhaps not two conditions.
All right. Any witnesses with regards to conditions for the court to set?
Yes, Your Honor, we would call Mr. DeLeon.
All right, Mr. Deleon, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Luis Deleon.
All right, defense, you may proceed.
So, Mr. DeLeon, the court is presently considering whether to grant you a bond on this motion to revoke, what that bond should be set at, but she also needs to know if there's any special conditions that need to be imposed as a condition of your bond. I'm going to ask you about a couple things in particular. First, I want to start with any history of mental illness that you might have. Do you have, or have you had in the past, a diagnosis for any mental illness or disease?
No, sir.
Are you receiving or have you received in the past any treatment or therapy for mental health issues?
No, sir.
Okay, I want to ask you also about substance and alcohol issues that you might have. Have you ever received any treatment or counseling, whether court-ordered or voluntary, for any substance abuse or alcohol abuse issues?
No, sir.
Okay. You're under oath, and can you affirm to this court that you do not have an issue with substance or alcohol abuse?
No issue, sir.
Are there any
Alright.
other I'm sorry, are there any other special conditions that you're aware of that this court might need to impose as a condition of your bond?
No, sir.
Okay, thank you, Judge. I'll pass the witness.
Any questions?
And if I may just talk about procedurally, the new case, judge, not the substance of the new case.
Yes, can you tell me the name of the complainant?
In the new case, judge,
Yes.
it is Ms. Natalia Aguilar.
All right.
Mr. Deleon, did you get picked up in a bond set August of 25 this year from the new assault case?
Yeah. Yes.
You get arrested?
Yes.
In August?
Yes.
They set a bond.
Yes.
And then was that bond forfeited?
I'm not sure, honestly. I believe last I heard it was like 4,000.
Did you get rearrested in that case?
It's in August.
Yes.
I turned myself in for the MTR.
You turned yourself in for the MTR.
Yes.
Were you aware that there was a failure to appear in September?
No. When I talked to my probation officer, it was August 27th, I believe, and she said that she was gonna, I guess, I don't know what it's called, but essentially she was gonna, so that there was no violation, she was gonna essentially, I don't know, waive it or something like that. And then once I turned myself in, everything would sort itself out.
Or they set that bond again, September the 4th?
I'm not sure, sir.
No additional questions, Judge.
All right. So do you all anticipate this being a contested hearing?
Unsure.
Well, Your Honor, I guess you've looked at the MTR at this point. There's a new number one that would be contested. The number two allegation, I need to confer with my client, but I don't know that would be as contestable. So I am.
All right.
Ms.
Ms.
That's the
Ferguson?
best I can tell the court today.
All right, this is going to be set for a contested hearing. Ms. Abrams, are you able to have, if there's a need for an officer, are you able to have that officer here? We can put it on December, either December 9th or December 16th. All
Judge,
right,
oh,
yes.
okay. Is December 11th available? Because I have some other cases in your court that day.
All right, let me see. Ms. Abrams, is December 11th?
Yes, I.
All right, December 11th. And Yaya, could you do a reset form for contested hearing? So your contested hearing is going to be December 11th. You need to be here. If you're not released, you will be brought over from the jail. So the court is going to follow your agreement. Bond is going to be set at $50,000. There's to be no contact with the complainant and the alleged new number one. And state, do you believe you'll be able to contact the complainant to let them know he's received bond today?
Yes, Judge.
This is a classic high drama bond moment. $75,000, no contact with the complainant, partial GPS monitoring. Each term here is a tactical chess move. The court is managing risk, ensuring public safety, and still giving the defendant legal breathing room. And for the audience, pay attention to how negotiation between defense and state sets the tone. This is where strategy meets real-life stakes.
All right,
Is this the complainant on the new number one, Judge, or the complainant on the underlying offense?
both.
We'll let them both know. And for the court, we were discussing several times.
Oh, the defense wrote on here that, that was the original bond amount, correct?
The original was 50,000, that's correct.
That's what was written on. I thought that was the agreement. So do y'all have an agreement or no?
I think we did, Judge, accept that.
All right, then the court will follow your agreement. The court will set your bond at $75,000. As I said before, there's to be no contact with the complainant and the allegation of the new number one. And of course, there's continued no contact with the complainant for the instant case. Do you understand? All right. So parties, if this is going to be contested, you all need to be prepared for a contested hearing on December 11th.
Yes, ma'am. Judge, the state further was asked for GPS, but that part was not.
All right. Mr. Valentine, the state is asking for GPS. You're opposed?
We oppose that, Your Honor. We don't believe it's a necessary condition in this case.
All right. And state, what is the reason for your request of GPS?
The underlying offense, Judge, for which he was placed on probation just earlier this year, pled to indecent assault, and was pled down. So he's only been on supervision for 6 months, 5 months, 6 months before he's rearrested for this new offense, which is another violent offense on the state. He is a danger now.
All right. And defense?
I'm having a little trouble hearing Mr. Morris, but I believe the concerns he's expressed would not justify anything like full house arrest. I don't think that GPS is necessary. This is not an instance of some sort of assault or improper contact with the victim in the case before the court. So, Your Honor, we would either ask that GPS not be imposed and that issue be left to the misdemeanor court's discretion handling the new number one, or if the court does see fit to impose GPS, it be tracking only with to monitor any contact that he might have with the two no contact subjects in the case.
All right. This is what the court will do. There's a $75,000 bond, which is agreed to by both parties. There's to be no contact with the complainant in the instant case or in the allegation of the new number one. There's to be partial GPS, waive fees, and that is for attorney consultations. Is there anything else?
Nothing from the state judge.
So,
Judge, may I ask that that partial be extended to any employment provided proof of employment is provided to the tracking provider? Or
once there is employment that has been obtained, then the court will consider that at that time.
Thank you, Judge.
All right. So what that means is you're allowed to go speak with your attorneys. That is it.
Boom. Here's where the rubber meets the road. GPS isn't just tracking, it's a court-enforced leash. Defendants must leave straight to appointments, no detours, no casual stops. It's fascinating. Legal restrictions manifest physically in someone's daily life. Think of it as the invisible strings of the justice system. And yes, those strings are very real.
So if you drive to your attorney's office and you see an HEB and you're like, I should stop at the HEB, you're not allowed to do that. You must leave from wherever you're stationed with your GPS. If it's at your home and you have an appointment with your attorneys, pretrial services is going to want to know of that appointment. And then you are to leave there without making stops to meet with your attorneys. Do you understand? Is there anything that you do not understand about the court's orders? All right, so you'll be back on December 11th. That will be for a contested hearing. Both parties will be prepared to proceed at that day. All right, is there anything else from the state or the defense?
Mistake.
Nothing from the defense. Thank you, Judge.
All right, thank you. All right, you're excused. Robert Porter. Who do you have? All right, is this a motion to revoke?
It is, and we're ready.
Okay. All right, the court is calling Isaiah Johnson or Asai Johnson. Could our parties announce for the record? Could I have a file stamp for a motion to revoke, please?
Ready to go forward.
Okay.
And Mr. Porter?
Oh, it's not.
Okay, then we have to set it for contested.
All right, this is going to be contested.
It is. I'm ready for my contestant right now.
Okay. All right, so we're setting this for a contested hearing. All right, Mr. Johnson, your contested hearing will be set in December. All right. Is there going to be any objections to witnesses appearing by Zoom?
Yes.
All right.
Your Honor, we bring, leave, probation officer from Florida to testify to a single allegation, so we'll have to see if we can accommodate.
Okay. All right. If you all confer on well, let's do this. On this case, Ms. Ferguson, if you recall it for the first week in December, and at that time states you'll need to be able to tell the court when you'll be ready for a contested hearing and making arrangements for the person in Florida to be here.
Yes.
All right, we'll see you back on December 4th. All right, thank you.
Thank you, Judge.